Hi, it's Scott Solkoff with more tips and treasures on caregiving. And today I'm going to talk to you about advanced healthcare directives. These are the documents that most of us refer to as living wills, healthcare surrogate designations, healthcare powers of attorney, do not resuscitate orders or DNROs. Other states have different names, physicians assisted orders for life sustaining treatment. But in essence, all of these documents share one thing in common, and that is that they are your wishes about what you want to happen at end of life, before end of life. So these are healthcare wishes that you're making in advance of needing them. Most folks that do advanced healthcare directives are saying what they don't want to happen at end of life. They're talking about saying, well, I don't want to be kept alive by machines. I don't want to be artificially sustained. I want to go naturally and peacefully. Other folks are saying fly in new machines, make every effort to keep me alive. And there's no right or wrong way. It's your own individual wishes. But if you fail to put those wishes to paper, nobody will know what you want. Even if you've told other people, there could be discrepancies in what they say to the doctors, or other folks could find fault with what that one advocate is telling the physicians. So the best way for you to do this, and every state now has laws enforcing your right to do so, is to put those wishes to paper in the form of advanced healthcare directives. Now, different kinds of advanced healthcare directives. The most commonly known is called a living will. A living will is where you say what you want or don't want to happen at end of life. A healthcare power of attorney, another legal document, is a document that allows you to say what you want to happen for your agent to be able to speak for you and on your behalf to the doctors with regard to your healthcare decisions. A healthcare surrogate, some states known as a healthcare surrogate, some states known as a healthcare proxy, is the person who you appoint to be able to make healthcare decisions on your behalf, but who, unlike a healthcare power of attorney, has more enforcement rights, better timing to get into court to enforce quick decisions, and depending upon the state, the right to be able to terminate treatment, withhold treatment, withdraw treatment at end of life. Some states, it's better to use a healthcare surrogate and a healthcare power of attorney. These are issues that you need to talk about with your lawyer. Now, tip number one: no form will satisfy all of your needs. You're your own person. You have your own wishes. You're unique in your own personhood. And I'll guarantee you that if I talk to you and 10 of your friends, we'll come up with 11 different or 20 different wishes about healthcare. Everybody has a different sense of what they want or don't want in different circumstances. So discuss these with an elder law attorney, because elder law attorneys are expert in this field and can ask you the questions you wouldn't have even thought about, so that you can put those wishes to paper in an efficient way, in an enforceable way, and protective of you and your surrogates. Don't think that you have to shoehorn your wishes into somebody else's form. Most people that have living wills, or healthcare surrogate designations, living wills especially, just fill in the blanks, sign at the end, and then are really surprised when they actually sit down and read and understand that document in light of all of the other issues that come up. So consider being able to put your own wishes to paper. All right, my cheat sheet. Tip number two, pain medications. Most folks will say in their living will that they do not want to be kept alive by artificial procedures. Yet most folks also, if you ask, will say that I don't want to be kept alive by artificial procedures, but I do want pain relief used to ease my suffering at end of life. Well, many physicians, healthcare providers, will look at pain medications as an artificial procedure. So if I say I don't want artificial procedures used, but I'd fail to define what I mean by artificial procedure, and I fail to specifically exempt pain relief, it can cause problems. Depending upon the state, more problems than others. So, recommendation, put an exception in the document for pain relief. Say that you want pain relief to be used to alleviate suffering, even if that pain relief could indirectly shorten your life. And this happens, for example, unfortunately or fortunately, depending upon the case, with morphine. So make clear your wishes. Tip number three, consider a liability shield for your healthcare providers. Now, here's what I mean by that. The number one reason why living wills are sometimes declined, or why they're not honored, is because doctors or the lawyers at the hospitals are worried about liability. Well, we put a clause in the document, and you can put one in yours, talk to your lawyer, about relieving the doctors and the healthcare providers of liability so long as they honor your wishes that are detailed in that paper. Now, it's questionable whether this clause really will have any effect, but I can tell you that in the real world, this clause helps. I've seen it help because it makes the healthcare providers at least feel better, and therefore your wishes are more likely to be honored. Multiple surrogates. This is an important issue. Most folks name one person who's going to be their healthcare spokesman, and those documents typically say, this is usually in a healthcare surrogate designation, those documents usually say, if I cannot speak for myself, I want so-and-so to speak for me. Well, I suggest that you have at least 2 people, maybe more, named as your healthcare surrogates. What if your primary surrogate, what if that first person can't act for you for whatever reason? Maybe they're ill themselves, or maybe they die before you, or they're out of town, just can't be reached. So it's a very good idea to have more than one healthcare surrogate. And picking these surrogates, the key factor is not location necessarily, because I have clients whose kids live on the other side of the world. But these days, with emails and faxes and telephone calls, things can happen from afar. The key factor in selecting your surrogate is whether they are of like mind to you, whether they will honor your wishes and do as you would want them to do. Now, when using multiple surrogates, my suggestion is to consider how you want them to be able to sign. You may want to appoint co-surrogates who serve together where only one signature is necessary so that the doctors, facilities aren't waiting on everybody getting together at the same time in order to get action. Or in your circumstances, you may want it where we require unanimity. These are issues to discuss with your elder law attorney because from state to state, these issues can vary in terms of enforcement. Tip number 5, make sure your surrogates have all necessary credentials. Depending upon the state, you may want to give your surrogate, for example, the right to be able to make funeral arrangements on your behalf, to refuse an autopsy of your remains, to be able to do organ donation. There are a number of issues that it may become important for you to specifically give authority in that document. So consider that too and talk about that with your lawyer. Tip number 6, consider putting in the document the ability for your surrogate to approve experimental medical procedures. In some states, the appointment of a healthcare surrogate in and of itself is not enough. If the states will not allow that surrogate to approve experimental medical procedures, procedures that are not yet approved by the FDA, even if those procedures could be very helpful to you. So put your wishes in the document. Tip number 7, a liability shield for surrogates for expenses. Well, one of the things that we've seen lately in Florida and are starting to see in other states are the healthcare facilities trying to stick the surrogate with the bill. So this is the kids that sign the documents or direct treatment getting a bill from the hospital or nursing home for your treatment. Well, one way that we've used to stop that is by putting a clause in the document that authorizes that surrogate to be able to sign, but when they sign, they're signing on your behalf. And therefore, we're making it clear and giving instructions to that surrogate on how to sign that they're signing in a representative capacity. They're not individually liable. Well, this can be very important. Number 8, notarization and oath. Consider notarizing the document even if it's not necessary in your state. Makes it more official, more likely to be honored. Number 9, organ donations. Did you know that in many states your surrogate can authorize organ donations even if you never authorize same during your lifetime? Consider what you want and put it in the document. Tip number 10, the location of the documents. This is my wallet. It's one of those George Costanza wallets. It has everything in it. Hotel key, Fund Pass for Fund Depot, Fund Pass for Fund Depot, Costco card. Here it is. This is a card that we give to all of our clients, and you can make up one of these yourself. It's a flash drive that I carry in my wallet that has my healthcare documents on it. Plugs into any computer so that if I'm injured, they can see my healthcare surrogate's name and address and all of that information. So those are 10 tips and treasures for you.